Mason v. American Emery Wheelworks, 1957, citizen of manuscript, filed suit in federal court in re against Recorp. Distance. Redetermined that Mississippi law applied B/C reused most significant contacts test, and injury occurred in manuscript. 1. Last time question of tort liability of a manufacturer to 1. Not in privity of K went to Supreme Court of Mississippi, highest state court. It decided a very harsh rule that only allowed for recovery where there was privity of K between user and manufacturer. 2. Fed court could tell that this was a harsh rule and was outdated. Supreme Court of Manuscript never had a chance to overrule it and would likely reconsider and revise Rule I. In recent ruling, Manuscript Supreme Court indicated awareness of modern trend in the area, contrary to Manuscript Court's previous holding, and quoted with approval more recent authorities in support of modern doctrine too. If state's highest court has not declared the state law in question, general view is that federal courts must act as another court of the state and choose from a variety of sources, high court dicta and lower court rulings. Downloaded from outlinedapp.com. 17. Adjudication other than by trial I. Summary judgment. Rule 56. A. Standard for summary judgment 1. 56. Viewing facts in a light most favorable to non-moving party. If Movin shows that there is no genuine dispute as to any material facts, then entitled to judgment as a matter of law. I. There cannot be any clash of evidence. II. If there is any evidence on both sides, then summary judgment will be denied. However, if one side has evidence and the other side does not, then summary judgment can be granted. 2. 56. C. 2. Hearsay does not constitute a genuine dispute of facts. Evidence must be admissible at trial. 3. If moving party will bear burden of proof at trial and submits evidence, and non-moving submits no evidence, still may deny summary judgment if there is reason to doubt the evidence. Self-interest. Motive. I. Cross v. United States, 2nd C. 1964, was a professor who went on a trip to Europe, wanted to deduct trip expenses from tax, had burden at trial, and moved for summary judgment denied. Has burden of proof and jury may not believe his evidence. 1. Factual issue as to purpose of S-trip. Is it to improve language teaching skills or is it a vacation? I. Most of these facts are within his own knowledge, should have opportunity to cross to test credibility. 4. Not necessary to have direct evidence to defeat summary judgment. Circumstantial evidence may be enough. Movant can submit affirmative evidence to negate an element essential to opposing parties' claim/defense. I. Dykes v. S.H. Chris & Co. 1970, claimed that refusing to serve her was a violation of civil rights and had conspired with police officer to get her arrested. Moved for summary judgment denied. Did not carry burden as movant of showing absence of any disputed material fact. As affirmative evidence was insufficient to negate essential element. 1. Submitted affidavits from store manager, chief of police, and arresting officer. Scottus says not enough. B/C has evidence that police officer was in the store and another store employee could have spoken with officer, not just store manager. 5. If moving party will not bear burden at trial, then moving party just has to show non-movant, who will bear burden, has insufficient evidence to establish an essential element. I. Celotex Corp v. Cartwright, 1986. Husband died from exposure to products containing asbestos manufactured or distributed by 15 named companies. Bears burden at trial and moves for summary judgment and submits no evidence granted. After discovery, had no admissible evidence that it was asbestos. All had was documents that were inadmissible hearsay and would bear burden at trial. Doesn't need to submit evidence. 1. If all of S evidence at the time is inadmissible at trial, then if it did go to trial, no one would have evidence and would lose. B/C they had burden of proof. B. Summary judgment cannot be granted without a reasonable amount of discovery. Downloaded from outlinedapp.com. 18. 6. If there is conflicting evidence, but there is objective evidence such that no reasonable jury could believe one party's evidence, then that party's evidence can be disregarded. I. Scott v. Harris, 2007, gets seriously injured after his vehicle was forced off the road by police officer, moves for summary judgment and there is conflicting evidence granted. Videotape is objective evidence showing that S evidence is untrue. Disregard S testimony and grant summary judgment. 1. Basically, if they went to trial and bears burden, video evidence is objective evidence such that no reasonable jury could believe S version of events would not have carried burden and would lose anyway. 7. Standard of proof is relevant to the summary judgment decision. If non-movant bears burden of proof under a clear and convincing standard, and evidence submitted at time of some judge motion is insufficient to satisfy clear and convincing, then grant some judge. I. Anderson v. Liberty Lobby, 1986, sued for libel and other shit, bears burden of proving by clear and convincing evidence that acted with actual malice, moves for summary judgment granted. Just had indirect evidence for proving actual malice, and submitted affidavit of author of allegedly libelous articles. Did not have clear and convincing evidence such that a reasonable jury could find for 1. If they went to trial, would fail clear and convincing standard, and would win. 8. Court can disregard a theory as implausible. I. Matsushita Electric Industrial Co. v. Zenith Radio Corp. 1986, antitrust case, alleged that Jap manufacturers and distributors conspired to fix prices to monopolize American market. Move for summary judgment granted. Court failed to consider the absence of a plausible motive to engage in predatory pricing if had no rational economic motive to conspire. And conduct is consistent with other, equally plausible economic explanations. Conduct does not give rise to an inference of conspiracy. 1. Alleged conspiracy is economically irrational. B/CS would have to take massive losses and hope that they recover someday. B. Result may be a function of antitrust element. Inferences drawn in antitrust cases are limited by economic factors. B/C no company would enter into a conspiracy that is economically irrational. B. Rationale for summary judgment. 1. Big cost and time saver. Efficiency. 2. However, we don't want to usurp the function of the trial. Therefore, if there is any clash in evidence, no summary judgment. Second, judgment as a matter of law. Rule 50. A. Basic standard. If party was fully heard at trial and no reasonable jury could find for non-moving party, then judge can enter directed verdict. Operatively very similar to some judge. 1. Policy reasons. Purely for reasons of justice. Jury was wrong. Cannot be for efficiency reasons. B/C trial already happened. Much more controversial than some judge. B/C we believe in jury trials. 7th Amendment preserves right to jury trial. Know that there is an absolute right to trial by jury, which Scottus interprets as right to jury trial shall be kept as it was when created in 1791. Downloaded from outlinear.com. 19. In 1791, not every case had to go to jury, or that every jury verdict had to be accepted. However, always accepted that jury had control. 1. Jury had control through demurrers. Admits that even if S evidence is true, should still lose. If demurred case and lost, Movant lost entire case. 50. Just sends case to trial. Seems like a more just result. 2. Denman v. Spain, Miss 1961, was in Ford with grandmother and got in an accident. Executrix of decedent's estate, who was driving Plymouth. Everyone but and one passenger in other car died, but neither remembers the accident. S motion for JNOV is granted. Bears burden of proving by a preponderance of the evidence that operator of car was negligent and that such negligence proximately caused or contributed to collision. No evidence indicating how the accident happened. No witnesses to accident. Only witness testified to speed of Plymouth, but not Ford, and that Plymouth was on correct side of road and driving straight. No evidence of causation. No way to determine who was at fault. No evidence. So party bearing burden of proof loses. B. Judgment as a matter of law. Directed verdict. Rule 50. 1. Judgment can be granted against a party if a reasonable jury wouldn't have a legally significant evidentiary basis to find for the plaintiff. Essentially the same as summary judgment motion. Cannot enter if there is conflicting evidence. B. If evidence now is exactly the same as when made motion for summary judgment, then must deny judgment as a matter of law. C. If evidence is different from when made motion for summary judgment, then can grant judgment as a matter of law. Almost always denied. If you enter judgment before going to verdict, but judgment ends up being wrong, new trial. B. If you allow case to go to jury and then enter JNOV, but judgment ends up being wrong, just enter jury verdict. 1. Starting new trial is a waste of time and resources, so directed verdict is almost always denied. 2. Galloway v. U.S. 1943. Constitutional challenge to directed verdict on ground that it violated 7th Amendment. 7th Amendment preserves right to trial by jury as it existed in 1791 and 1791. Courts were not deprived of power to withdraw cases from jury. Still had demurrer and motion for new trial. Objection is not to power of court to withhold cases from jury or set aside verdict for insufficient evidence, only to incidental effects. That directed verdict as administered now differs from procedures in 1791. B. Amendment does not bind Fed courts to the exact procedural incidents or details of jury trial in 1791, just preserves the basic institution of jury trial in only its most fundamental element. C. Judgment as a matter of law after the verdict. JNOV. Rule 50. B. 1. Judgment can be granted against a party if a reasonable jury wouldn't have a legally significant evidentiary basis to find for the other party. Downloaded from outlinear.com. 20. Jury will come back with verdict, but judge will say no reasonable jury could have come out that way too. Granted much more commonly than directed verdicts. We want to give jury a chance to get it right. If judge gets 50 wrong, then need whole new trial, but if get 50 B wrong, then just goes to appeals. 3. Must make a motion under 50. To make a motion under 50. B. Miley v. Martin KAB Construction, 1967, sues for wrongful death claiming negligently constructed, maintained, and supervised missile silo which proximately caused death of S father when he fell off a platform while working at silo. Moved for directed verdict under 50. Get denied. B. Moved for JNOV under 50. B. And alternatively for a new trial, distance denied, but COA reverses dismisses case. 1. Claims COA, after reversing denial of Rule 50. B. Motion, cannot order dismissal or direct entry of judgment. B/C did not have opportunity to present grounds for new trial. Scottus says no. B/CU can petition for a hearing, or should have done so in brief. I presented no new trial issues that would force COA to remand, and COA could have ordered new trial on its own motion / remanded. D. What important policies would be furthered by getting more cases to the jury? 1. Good about juries. We have trust in the community and a distrust in the government. Therefore, justice should be handed out by juries. Diversity of opinions. Voice of the community. Empowers the minorities, not just white males making decisions. Jury as the party's peers. Don't have to take precedent into account. V. More people making decision. 2. Bad about juries. Don't have to take precedent into account. May be too dumb to handle certain types of cases. More swayed by bias, prejudice, and sympathy for an injured plaintiff. Unpredictability. V. Inconsistent outcomes. 3rd. New trial. Rule 59. A. Motion for a new trial gives judge discretion as to whether they believe the evidence of the parties. Judge is permitted to consider credibility of the evidence. 1. JMOL gives judges less discretion in this regard. B/C JMOL is not about subjective believability of evidence, but objective credibility. No reasonable jury could have come out that way, so judge must enter verdict to the contrary. On a motion for directed verdict, judge must utterly disregard his own views of witness credibility. B. Standard. When jury verdict is against clear weight of evidence, then judge can order a new trial, and therefore does not enter judgment. On close calls, judge should defer to jury's verdict. 1. Prevents parties from getting an unjust result from a runaway jury, but assumes that judge is right and jury is wrong. Downloaded from outlinedapport.com. 21. 2. Most appellate judges will affirm a trial judge's decision to grant / deny a new trial. B/C trial judge was there to weigh the evidence. Proximity to evidence leads to more accurate results. C. Eatna Casualty and Surety v. Yeats. 4th C. 1941. Denied liability on ground that was engaged in performance of criminal abortion at the time he incurred the liability for which recovery was had against him, and that such liability was expressly excluded from coverage of policy. Jury finds 4. Did not file for directed verdict. Moves for JNOV or new trial. 1. Denies motion for JNOV. Evidence for both parties. Therefore reasonable jury could find for Dr. Didn't file for directed verdict. 2. On Rule 59 motion, it is duty of judge to set aside verdict and grant new trial if he is of the opinion that the verdict is against clear weight of evidence, is based on false evidence, or will result in miscarriage of justice. Distinction for granting new trial and directed verdict. Substantial evidence in support of S case. Judge may not direct a verdict against him, even though he may not believe his evidence, or may think that weight of evidence is on other side against constitutional guarantee of trial by jury, and jury is supposed to weigh evidence and pass upon credibility. B. Judge may set aside a verdict supported by substantial evidence, where it is contrary to clear weight of evidence, or is based upon evidence which is false. Even though evidence is sufficient to preclude directed verdict, judge still has duty to exercise power to prevent miscarriage of justice. 4th. Dismissal. Rule 41. A. Voluntary dismissal. Rule 41. 1. Why would want their case dismissed? Most common. If the case settles, then needs case dismissed. Less common. If realizes they screwed up, that is want different forum / CT. Sol has run etc. 2. Voluntary dismissal without a court order. 41. 1. A. P files a notice of dismissal before opposing party serves an answer or motion for Society of Jesus, then will get automatic dismissal, no court order. If D files motion for 12, B, 6, before files a notice of dismissal, can still get the dismissal. B/C 12, B, 6, is not an answer or a motion for Society of Jesus. 41. 1. Files a stipulation of dismissal, must be signed by all parties, then can get automatic dismissal, no court order. With or without prejudice. Generally without prejudice, can bring the case again, in a different court / forum etc. B. However, it will be with prejudice. S case is dismissed permanently, and cannot be brought back to court, if has already voluntarily dismissed the same claim. 3. Voluntary dismissal with a court order. 41. 2. P moves for voluntary dismissal by court order with or without prejudice. Generally without prejudice, can bring the case again, in a different court / forum etc. Downloaded from outlinedapport.com. 22. B. However, it will be with prejudice. S case is dismissed permanently and cannot be brought back to court, if it would be unfair to allow the to dismiss and then to start over. 1. Has P already voluntarily dismissed the same claim? 2. Would D be less well off in different jurisdiction? 3. Did D already litigate the claim for a while in this forum? 4. How much money / time has D already spent / put into this? 4. McCants v. Ford Motor Co. 11th C 1986, was killed while riding in a military jeep built by during 2-week active duty training mission. Brought suit in AL for wrongful death, but 1-year statute of limitations runs. B/C discovery lasts for a year. Moves for voluntary dismissal without prejudice, so she can file in Fed court in manuscript. I. Voluntary dismissal should be granted unless will suffer clear legal prejudice other than mere prospect of a subsequent lawsuit when has been put to considerable expense. Dismissal is not warranted except on condition that reimburse for a portion of expenses. 5. Watchtest v. Capital Guardian Trust, 7th C 2007, owned IRA and instructed custodian to roll over investment into a new IRA, managed by a successor custodian, employee at successor custodian converted funds, and is convicted for mail fraud, sued original custodian for breach of fiduciary duty, moved for judgment on pleadings arguing they were time barred and that failed to state a claim upon which relief could be granted, responds to latter argument and moves for voluntary dismissal without prejudice. I. Denied S. Failure to respond to SOL argument was a waiver, and granting voluntary dismissal would be an abuse of discretion when would suffer plain legal prejudice. B. Involuntary dismissal. Rule 41. B. 1. Reasons for involuntary dismissal. I. Failure to prosecute, that is failure to move the case along at a reasonable rate, doesn't really occur anymore. B/C. There is a scheduling order, but it is still possible. II. Failure to comply with the rules. III. Or failure to comply with a court order. 2. If asks court for another chance, then court will look at whether was harmed. However, case may still be dismissed the absence of harm to preserve the efficiency of the court system. 3. An involuntary dismissal with prejudice is a very severe remedy. 4. Link v. Wabash, 1962, fails to attend a pretrial conference. Judge dismisses case without hearing S. Excuse for missing hearing. I. Court can dismiss a complaint for failure to prosecute without affording notice of its intention to do so, or providing an adversary hearing before acting, had missed other scheduled meetings, and delayed the case. Unexplained absence from pretrial conference alone may not justify dismissal with prejudice if record showed no other evidence of dilatoriness. V. Default. Rule 41. B. S version of Rule 41A. If serves process on, but never responds, no answer or defense through a motion. 1. Rule 55. Entering a default. I. Clerk will enter S default, simply a note that failed to meet a requirement, not a judgment. 2. Rule 55. B. Default judgment. I. 55. B. 1. Clerk may enter default judgment if downloaded from outlinedupit.com. 23. Is seeking a certain sum or a sum that can be made certain by computation, sum certain plus interest. B. Was defaulted for not appearing, and not a minor/incompetent. II. 55. B. 2. Court may enter a default judgment if not some certain, then must move for default judgment. 1. If it looks like a good case after just hearing S side, judge can offer default judgment, looks at allegations and evidence. 2. But if it looks like could have a defense if they were present, then judge will not enter default judgment. 3. Must have 7 days notice before the hearing. B. There could be a case where appears, but then still default shows up, files a REMTD, motion gets denied, must then answer, or else they default. 3. Rule 55. C. Setting aside default judgment. I. The court may set aside a default judgment for good cause, that is if was properly served, but never actually got it. II. However, even if has a good reason for defaulting, the court may not set aside the judgment if doesn't have a good defense. II. Judges usually set aside default judgments. B/C. Want everyone to have their day in court. B. Cowles v. Smith, Arizona 1964, responds to complaint and litigates, but then on day of trial doesn't show up, originally set for 10/6, but gets moved to 12/10, doesn't show up for either. On trial date, court heard S evidence and lost one. Files motion to vacate judgment nearly 2 years later. Like an asshole, obviously loses. I. Claims it was a default judgment and that he did not receive 3 days notice of application for judgment by default, but it wasn't technically a default judgment, really a judgment on merits. B/C. You can't default after you answered, just failed to show up to trial so didn't make your case. And 1. Downloaded from outlinedupit.com. 24. Trial, particularly trial by jury. I. Right to jury trial in federal courts. 70H Amend. A. 7th Amendment. Right of trial by jury shall be preserved. 7th Amendment doesn't create a right to jury trial, merely preserves the right as it existed in 1791. 1. 1791. There was a right to trial by jury in courts of law, but not in courts of equity. Today courts are merged. Rule 2. I. Court of law when seeking money damages. Everything else in courts of equity. B. Deciding who gets a jury trial in federal court must determine whether the case would have been in a court of law or equity in 1791. 1. What is S cause of action? 2. What is the remedy is seeking? More important. I. If is seeking money damages trial by jury. II. If is looking for relief other than monetary damages bench trial. II. But what if is seeking legal and equitable remedies? Try the legal claims first with a jury, and then if anything is left, try the equitable claims. B. If jury awards damages, the judge decides the equitable claim based on facts established by the jury. Equitable judgments are discretionary, so you might not get it. Judge considers balance of equities. C. Determining the legal nature of a claim. 1. Pre-merger custom in 1791 was claim legal or equitable? 2. The remedy sought. 3. Practical abilities and limitations of juries. Would jury do a good job Functional test. I. Complexity exception to right of jury trial may exist if case is too complex, then just hear as a bench trial, that is business or science heavy cases. Sending such complicated claims would violate due process. B. In 17,971. There was always a complexity exception. II. SCOTUS has never accepted complexity exception. Suitability of case for jury is not considered. D. What if the entire case wouldn't have existed in 1791? 1. Newly created claims by statute. Even though 7th Amendment says common law, it means common law versus equity, not common law versus statutory law. I. Jury trial still applies for new claims created by statutes. 2. Entity being sued was illegal in 1791. Unions. Two-prong test. I. What cause of action that existed in 1971 is most similar? II. What remedy is being sought? Money damages or equitable relief? Sometimes money is not money damages, and therefore is not a legal remedy. 1. If money relief is incidental or intertwined with injunctive relief sought in Title VII claims, reinstatement and back pay is a form of restitution, not money damages. 2. If a restitutionary claim, giving a what you were supposed to give them anyway, instead of compensating for damages incurred. I. How much gained? Restitution. Instead of how much was harmed. Damages. A. If measure of award is S harm legal. B. If measure of award is S benefit, or what was already owed might be equitable. Downloaded from outlinedupit.com. 25. E. Beacon Theatres Incorporated v. Westover, 1959. Legal and equitable remedies. Fox sues Beacon seeking declaratory relief against Beacon allegation that Fox's exclusive right to show first-run pictures in San Bernardino competitive area and clearance period of time no other theater can exhibit same film were violations of Schumann. Fox sues seeking declaratory relief and injunction. Beacon counterclaims. Mandatory B/C part of same transaction. For treble damages under Schumann and Clayton Acts. 1. Critical factual question to all claims is whether there was actual competition between Beacon and Fox, given that Beacon is 11 miles away. I. Declaratory judgment was unknown at common law. Declaratory judgment Act created right of one party to preemptively sue and have a court declare that party has done nothing wrong. Party would more naturally be the, but preemptively sues. With declaratory judgment claims, imagine the more natural case, Beacon suing Fox, instead of Fox suing for declaratory judgment, to determine whether remedies would be in equity or in law. Antitrust suits afford legal damages. Legal claim. II. Injunction is classic equitable claim. 2. Must try the claims in an order that does not allow the right to jury trial to be lost. Try the legal claims first by jury, then try equitable claims. I. Try Beacon's antitrust case by jury first, then if found that here was no violation, Fox would try equitable claim. If you try the equitable claim first and injunction is granted, Beacon loses. Beacon would lose right to jury trial. B/C of collateral estoppel. F. Dairy Queen v. Wood, 1962. Legal and equitable remedies. Sues for failure to make payments due under contract, providing exclusive right to use trademark. Once injunction to stop using trademark and accounting for exact amount of $sign owed. Injunction pending accounting. 1. Doesn't matter what part of claim, legal or equitable, is incidental. If any part of the case is legal, then that part must be tried with a jury. I. Accounting is just a word for damages, and therefore there is a legal claim embedded in this suit. Presumably, is seeking recovery of the amount owed following the accounting. Gets rid of the traditional cleanup doctrine. G. Ross v. Bernhardt, 1970. Legal and equitable remedies. S. brought a derivative suit in Fed court against directors of a closed-end investment company of which they were shareholders, alleging company charged excessive brokerage fees. Once a jury trial says there was no such thing as a shareholders derivative suit at law, but was traditionally an equitable suit. 1. Derivative suits claims brought on behalf of company by shareholder, usually to sue someone on board. I. Legal claim was wrapped in a procedural shell that was historically an equitable claim. Court should disregard the equitable shell and try the legal claim with a jury. H. Curtis v. Lowther, 1974. New claims by statute. Sues for violation of CRA Title 8. Fair housing. Claims racial discrimination is seeking money damages and injunctive relief. Once a jury trial. 1. Has the right to jury trial, while statute is ambiguous on whether it provided a jury trial. But the right of jury trial, when it exists, belongs to both sides. 2. Jury trial is required. Doesn't matter if is suing under statutory or common law causes of action. B/C still suing for money damages. Downloaded from outlinedupit.com. 26. I. 7th Amendment says common law, but it means common law versus equity, not common law versus statutory law. Jury trial still applies to new claims created by statute. 3. Not all awards of monetary relief must necessarily be legal relief. I. Title 7 versus Title 8 claims. Title 7 claims allow for reinstatement and back pay, which is an integral part of an equitable remedy, a form of restitution. I. Tull v. United States, 1987. Government sues in Fed court to impose a statutory monetary penalty on 4 violations of Clean Water Act. Tull demands jury trial. Government contends action is basically one in equity to abate a nuisance. 1. Compare statutory action to 18th C actions brought in courts of England prior to merger of law and equity. Then examine remedy sought and determine whether legal or equitable. I. Characterizing relief sought is more important than finding analogous common law cause of action. Civil penalty was a remedy enforced by law courts right to jury trial. J. Chauffeurs, Teamsters, and Helpers Local 391 v. Terry, 1990, suing entity that was illegal in 1791. Employees sue labor union for breach of duty of fair representation and want relief of back pay. Labor unions were illegal in 1791. 1. What analogous cause of action existed in 1791? I. Suing labor union for breach of fair representation is similar to breach of fiduciary duty. Analogizes to trust. Can't sue who they are actually upset with, but have to sue whoever is managing on their behalf, which is an equitable claim. B. But this is also analogous to CBA, similar to breach of K claim, which is a legal claim. II. This part of test is an equipoise. B/C. Similar claims existed in 1791 in both courts of law and equity. 2. What is the remedy sought? I. Are seeking monetary damages, which is clearly legal claim. Sometimes money is not monetary damages, and therefore not legal, but here it is. B/C. This was lost money, compensatory, not money they would have gotten from union anyway. Restitution, seeking damages from union, not employer. B. No injunctive relief sought. Second, the right to trial by jury in state courts. A. 7th Amendment does not apply to state courts. 1. State courts could do whatever they want, presumably could abolish jury trials for civil cases. B. But most states have their own provision in their constitution that is similar to 7th Amendment. 1. However, states still follow traditional cleanup doctrine when legal and equity issues ask what the dominant issue is. 2. Even in a state that follows the cleanup doctrine, if in federal court in that state, 7th Amendment still applies. Third, role of judge versus jury. A. The judge decides questions of law and the jury decides questions of fact. 1. Reasoning behind roles. I. Comparative advantage. We want each decision maker to make the decision on which they have a comparative advantage, and want a trained expert to decide questions of law. B. Want community to decide which party is telling the truth. Downloaded from outlineup.com. 27. II. Uniformity. If jury decided questions of law, then jurors may decide different things and there wouldn't be consistency. 2. However, it is not always clear whether something is a question of fact or a questions of law. I. Markman v. Westview Instruments Incorporated, 1996. Competing claims to a patent used to monitor clotting in a dry cleaning establishment. Part of dispute hinges upon meaning of word inventory. Meaning in a patent claim. Judge should decide what the word inventory means. 1. Comparative advantage. It would be too much for the jury to decide what the word inventory means in a patent claim. And 2. Uniformity. Patents are applicable to everyone, so good to have a uniform understanding of what patents means. B. Meaning in a K claim. Judge decides if it is ambiguous, and jury decides what ambiguities mean. 1. Jury could have experience with contracts, and 2. There isn't the same need for uniformity. II. Facts in a trial. Judge decides facts relevant to pretrial motions, while jury decides facts for ultimate merits of the case. If the facts are the same, jury trial is always more expensive and longer. 4th. Demand and waiver of trial by jury. A. Tactical considerations. 1. Might be happy with a jury trial. B/C will prolong trial and encourage to settle. 2. Might want to speed up trial by having a bench trial. B/C needs money quickly. 3. Judge generally rule for more, but juries will give higher damages if you are sure you will win either way. Probably better to opt for a jury trial. B. Jury trial by demand rule. 38. 1. If you want a jury trial, send a demand under Rule 38 and serve other party with written notice. 2. Party must file within 14 days after last pleading directed to issue is served. Can put demand for jury trial right in pleading, but better practice to have a separate document. 3. If you demand jury trial on all issues, then will get it, if entitled to it. 4. Rule 38. D. Party waives a jury trial unless its demand is properly served and filed. C. Jury trial by motion. Rule 39. 1. If you miss the time to demand a jury trial, can move for a jury trial. However, it is then up to discretion of trial judge. Typically judges won't grant it. B/C it extends the time of trial and messes up calendars. 2. The system prefers bench trials, efficiency reasons. Therefore parties must actively seek a jury trial. D. Why parties are required to make demand for jury trial within a specified time. We have a conflicted attitude about jury trials. 1. On one hand we love the right, it's in the constitution. 2. On the other hand, it's expensive and cumbersome / makes it very easy to waive the right. V. Choosing a jury. Rule 48. A. Rule 48. Number of jurors 1. Between 6 to 12. Jurors, up to court to decide how many people. Most commonly there are 8. B/C want as small as possible for cost and efficiency, but if a juror or 2 had to drop out it would be okay. Downloaded from outlineup.com. 28. 2. Empirical evidence shows that there's no difference between results returned by 6 jurors or 12 jurors. If this was absolutely true, then we would take the cheaper 6-person jury, but not actually sure. B. Impaneling the jury. 2 stages. 1. Coming up with a list of potential jurors, which must represent a cross-section of community. 2. Voir dire. Potential jurors are questioned by judge, Fed court, or by attorneys, state court, to determine if they can decide case fairly / appropriately. Jurors can be challenged for 2 reasons. I. Challenges for cause. Reason to believe juror will be biased or prejudiced. Flowers v. Flowers, Texas 1965, jury selection for child custody case. One potential juror indicated bias B/C juror was against drinking in any manner and would not grant custody to any parent who drank, even socially challenged for cause. 1. Disqualifying bias B/C. It would be the only consideration that juror was going to look at. Jurors can have attitude/beliefs, but can't just disregard the law. II. Peremptory challenge. Can deny a limited number of jurors for any reason, or no reason. Edmondson v. Leesville Concrete Company, 1991, is black, sued for workplace injuries. Use 2/3 peremptory challenges to remove black persons from prospective jury. 1. Constitution's protections of individual liberty and apply in general only to government actions. Racial discrimination violates Constitution only when it may be attributed to state action. I. Objective of jury selection proceedings is to determine representation on a governmental body. Entire process of determining who will serve on jury constitutes state action. 2. Exercise of peremptory challenge, even by private litigant, to strike juror based on race, violates sufficient governmental action. B/C. Participating in jury selection is an important function within the government and act with government's substantial assistance. I. Also, just for practical reasons, TBH can't just let people strike individuals from jury just based on race/gender, otherwise there is a risk of open and public discrimination as condition of participation in justice system. A. Mars integrity of judicial system and democratic government. 6th. Order of trial. A. Order of trial. 1. P's opening statement. 2. D's opening statement. 3. P's presentation of direct evidence. 4. D's presentation of evidence. B. Burden of proof. 1. Burden of production. Must bring enough evidence that a reasonable jury could find in your favor. If party fails to meet burden of production, then judge will grant summary judgment. If doesn't get to trial, or JMOL, if does get to trial, for the other party. 2. Burden of persuasion. The party with the burden must actually persuade the fact finder to find in their favor. If evidence is perfectly in equipoise, then jury must find against the party who has the burden of persuasion. Downloaded from outlinedapat.com. 29. I. Usually both burdens are on the same party, usually on the is the one bringing the claim, and therefore should bear the burden. II. However, typically if something is an affirmative defense, then burden will be on B/C would have better knowledge on the facts of the affirmative defense. III. 3 common standards. Preponderance of the evidence most common for civil cases. B. Clear and convincing evidence some civil cases. Libel, slander, child custody. C. Beyond a reasonable doubt all criminal cases. 7th. Jury instructions. Rule 51. A. Generally. 1. Judge instructs/charges jury with what the law is. 2. Jury decide the facts and apply facts to law. 3. Both parties submit proposal of instructions. Judge uses either 1. Instructions submitted by one party. 2. Comes up with own instructions that term or correct. Or 3. Pattern instructions, already formulated instructions proven to work. B. Objections to instructs. If counsel does not object at appropriate time, right to object is deemed waived. 1. Rule 51. B. Requires court to give notice to counsel of instructions at charge conference, where counsel can then object to chosen instructions. Need to object at charge conference. 2. Rule 51. C. 2. B. But if judge doesn't give instructions ahead of time, no charge conference or judge gives different instructions than previously stated, counsel must object at the moment instructions are given. 3. Rule 51. C. 1. Party must state objection and grounds for objection. 4. Rule 51. D. Court of Appeals must affirm a decision unless instruction was properly objected to, or if instructions were made in plain error. I. Plain error standard must be an exceptional/clear/vital error of law that causes a miscarriage of justice, affects outcome of case, not just a clear error, even if instructions are wrong, but not exceptionally wrong, and not objected to in right time/way. Court will affirm. 1. Putting burden of proof on wrong party is not a plain error. B/C. It only matters who has burden of proof if evidence is in perfect equipoise, i.e. policy reasons. If court reversed, then would need to have a new jury trial, which is expensive and timely. B. This gives incentive to counsel to pay attention and object at right time. 1. Without Rule 51, attorneys would sandbag incentive not to object to instructions that they know are wrong to double chances of success on appeal. 5. In practice, should object at charge conference, and when instructions are given. C. Jury instructions are often very difficult to understand. 1. Either the underlying law is very complicated, instructions are written by lawyers/judges who might not be good at writing simple instructions. 2. A simple instruction may be too simple and incorrectly/incompletely state law. 3. Secretary v. Koenig, 7th C 2009. Jurors were permitted to ask questions, take notes and get a copy of instructions to better understand case. Trial had dragged on for 12 weeks. Allowing jurors to ask questions is controversial. B/C they may ask biased/irrelevant questions and could bring in inadmissible evidence. Downloaded from outlinedupad.com. 30. Solution. Questions are asked to judge. Judge confers with attorneys, while jurors are dismissed, giving attorneys opportunity to object. Questions are asked of witnesses. 8th. Verdict and challenges to it. A. Jury verdicts. Rule 49. 1. 3 types of jury verdicts. General verdict. Jury states who wins and amount of damages, but doesn't answer any questions about case. Special verdict. Jury answers factual questions about case, submitted by judge, and judge decides who wins based on answers. General verdict with answers to interrogatories. Combination of special and general. 2. Entirely within court's discretion as to what type of verdict to use. If special or general with answers, it's up to court to decide what questions to ask jury. Typically, once general verdict with answers and once general verdict with a general verdict. Don't know reasoning behind the jury's verdict, and therefore jurors can technically use whatever law they want to decide who wins plus damages. 1. In a contributory negligence jurisdiction, jurors might not like contributory negligence, so will apply comparative negligence rule with a general verdict. Don't have to give reasoning, so jury can reduce the amount of damages to instead of having to lie and say wasn't negligent. B. With general verdict with answers, jurors have to focus on law that was given, can't just disregard the law when answering. 3. How should judges decide? Depends on the judge's view of the jury. If judge wants to stay strictly to the law, judge will choose general verdict with answers. But if judge views the jury as bringing an outside view, that can soften law, stick with general verdict. 4. What if with general verdict with answers, jury responds yes to D being negligence, yes to P being contributorily negligent, but then finds 4P. 49. B. 3. The judge can either 49. B. 3. A. Disregard the general verdict and correctly apply the law to the answers. B. 49. B. 3. B. Ask the jury to reconsider its answers. Or C. 49. B. 3. C. Order a new trial. Judge cannot enter judgment in accordance with general verdict disregarding the answers. We give preference to the answers. B/C we find that jury is the expert on the facts. Where answers and general verdict are in some tension, but the general verdict is legally possible, then judge should award general damages. A court can only invoke 49. B. 3. Where the answers and the general verdict cannot be reconciled with each other. If they cannot be reconciled, then judge will prefer the answer. But if there is any way to reconcile the two, then judge will prefer the general verdict. B/C we value the jury system. Judge cannot change jury general verdict unless completely irreconcilable with the answers, even if clear that jury misunderstood their directions and awarded incorrect amount. 5. Nalan v. United Airlines Incorporated. SD California 1963. Wrongful death action, where S liability was already established. Court used general verdict with answers, with questions intended to guide jury's calculations of damages for S wrongful death. Jury used PV to determine S lifetime earnings was expected to earn $235,000 over lifetime. PV was $173,4477, but jury actually awarded $114,655. Downloaded from outlinedupad.com. 31. Jury is not obligated to calculate damages based only on answers to questions. Jury can give whatever damages they think are appropriate. Jury's general verdict award was not irreconcilable with answers where general